Ladies and gentlemen, thank you for taking the time to be with us today and welcome to the M&A Academy program and our fourth webinar in the 2023 program. My name is Nidhi Kilawala and I am an M&A partner in Khaitan and Company's corporate M&A group based in New Delhi. I would like to extend a very warm welcome to this webinar to every one of you, whether you are in our audience in India or around the world. Thank you for taking the time to be with us today. For those that have not attended before, I note that the M&A Academy program is designed to provide foundational legal knowledge and understanding on M&A transactions and processes to corporate executives, in-house legal teams, and others participating or interested in M&A in India today. Our subject today is business purchase agreements, structure, and key terms. The format today will be a formal presentation on today's subject, followed by a Q&A with audience questions. We've already received some audience questions in advance, and if you still have more questions, please feel free to submit them using the facility provided in the webinar portal. If we cannot cover all questions during the webinar, we will be sure to respond to those questions offline by email after the webinar. You will also receive a copy of the presentation along with summary notes of the presentation and a recording of the webinar after the presentation as a matter of course. M&A is an important part of our firm's practice with more than 50 partners dedicated to this area because India is experiencing massive growth in M&A transactions. Last year, we covered share sale transactions and asset sale transactions in considerable detail. And if you have missed those sessions, I refer you to Khaitan and Company's YouTube channel where recordings are available to view at your convenience. Today's subject is a logical extension of what we have already covered in the M&A Academy, because in many cases, a business sale is a very real option for parties to consider as an alternate to a share sale transaction. In some cases, a buyer may have good reason to opt for a business sale transaction instead of looking to purchase securities of that company. For example, in situations where there is a certain liability that the buyer is uncomfortable taking on, or a liability that simply cannot be quantified, then in such cases, a business transfer agreement becomes a very real option to buyers in such instances. And today we will spend some time talking about the manner in which a business purchase agreement is to be structured and the advantages and disadvantages that need to be evaluated at the time of structuring the transaction. For this reason alone, it is important for you to understand business purchase agreements, which of course is our objective today. Our speaker today is Suhana Islam Murshid, who is an M&A partner based in Kolkata, although she works nationally, as do all of our corporate M&A partners. Suhana has been with Khaitan and Company for 8 years and became a partner in 2019. She specializes in M&A and is very experienced in this work. Most of you have already received her CV by email, so I will not go into too much detail regarding her experience, but some of her recent notable assignments have included Reliance Jio's acquisition of ShopSense Retail Technologies, TVS Motor acquisition of e-Mobility Group, and acquisition of a majority stake in Medica Synergy Private Limited for a Temasek subsidiary. It is difficult to think of a better partner to share her knowledge with you on this topic today. So I now invite Suhana to deliver her presentation.
Thank you, Nidhi. Good afternoon, ladies and gentlemen, and a very warm welcome to all of you to today's session, which is titled Business Purchase Agreements, Structure and Key Terms. Now, as you may know, there are various modes of acquisition that are permissible in the M&A ecosystem. For example, the parties may choose to have a court-driven process, as is in the case of a merger or a demerger, or a buyer may want to acquire the shares of a company by way of a share purchase agreement. It's also possible to have an itemized sale of certain cherry-picked assets by way of an asset sale and purchase agreement. Or one could even consider an acquisition of stressed assets under the Insolvency and Bankruptcy Code regime. Now, for today's webinar, the topic is business purchase agreements, which is a fifth mode of acquisition, wherein there is an entire undertaking or a business activity that is being purchased. Now, to my mind, business purchase agreements offer two unique propositions. First of all, it allows the buyer to acquire a ready and operational business that it can conduct from day zero of its acquisition. And secondly, the key differentiator really is that a business purchase is intrinsically linked to certain tax considerations, and we are going to consider those in a moment from now. Now, for the agenda for today's session, I've roughly divided my presentation into two broad portions. In the first part of my presentation, I'm going to talk about certain key conceptual aspects of a business transfer, including some of these tax considerations and stamp duty. And in the second part of my presentation, I will deep dive into certain transactional considerations, including conditions precedent, transfer clauses, and risk mitigation. Finally, I'll wrap up my session with certain key takeaways. Next slide, please. Now, as I've mentioned to you, a business purchase is quite unique in the sense that it is intrinsically linked to certain tax considerations. Now, in India, one must bear in mind that when we talk about a business purchase, it is often referred to as a business transfer, or in Indian parlance, more colloquially, sometimes just as a slump sale of business. Now, what is a slump sale of business? When a business is transferred from the seller to a buyer, and it meets certain conditions which are prescribed under the tax laws, then it is termed as a business transfer by way of a slump sale. Now, there are certain important tax considerations, the main being, and for now it is just sufficient to know that there is a separate mode of computation of income tax when it comes to a slump sale, which is generally speaking considered to be more seller efficient and friendly. Now, with that, let's understand what is this concept of a slump sale. So in a slump sale, and this is defined under the Income Tax Act, in a slump sale, there are four essential conditions that must be met. First of all, it must be a transfer of an undertaking. Now, what is an undertaking? An undertaking is nothing but a separately identifiable standalone business activity. So for example, we may have an airline which runs both a cargo division as well as a passenger airline business. Now, if the cargo division is being sold off or transferred, then in order for it to qualify as an undertaking, it must have all the infrastructure that is required for it to carry on the business. So for example, it must have all the assets, all the liabilities, must have all the contracts, employees, licenses and permits and what have you, whatever is required really to carry on the business. And it is this business that must be transferred as a going concern basis, which is the second condition or the leg of a slump sale, that there should be no cessation in the business operations or activities. It must seamlessly pass on from the seller to the buyer. Again, this transfer could be by any means, which means that it could be for a sale, for cash consideration. It could also be for consideration other than cash. And finally, to my mind, perhaps the most critical aspect of a slump sale is the fact that the consideration that the buyer pays must be a lump sum consideration. Now, what that means is that separate values should not be assigned to any of the components of the business. So, for example, values to assets, liabilities, goodwill, etc., should not be separately provided. There should be one separate lump sum consideration, like one whole for the entire undertaking that should be mentioned in your business purchase agreement. The only exception that is provided under law is that it is possible to assign values to the different components of a business undertaking for the sole purpose of arriving at stamp duty and registration fees. Now, a business purchase also allows certain other unique aspects for the purchaser and the buyer. The first one being that it is possible to exclude certain assets and liabilities from the whole ambit of the undertaking that is being transferred. Now, one must bear in mind and tread with caution here, really, because while excluding these assets and liabilities, relevance is, and the important point to consider is whether we are losing the character of an undertaking. Does that chip away into the meaning of an undertaking as it is understood under the Income Tax Act? Now, it is possible, like I mentioned, to exclude certain assets, but these are usually a minimal list of assets, and they are usually, for example, assets which are not intrinsically linked to the business that is being transferred, or it could be assets such as certain employees who are not really employed or engaged with that particular business, or certain contracts, or even intellectual property. For example, if a seller wants to retain certain trademark even post transfer, then that would typically be something that is excluded. Now, for excluded liabilities, again, this becomes very critical, especially for a buyer, because this allows the buyer to really lean back on the diligence that it has conducted. And typically, large litigation claims or tax claims which are known to the buyer could be excluded, again with caution that it should not take away from the very concept of an undertaking. Another unique aspect that a business purchase allows is risk allocation. Now, it is possible in a business purchase to have the business transfer done from a retrospective date. So, for example, if the seller and the buyer enter into a business purchase agreement and that is closed and the transfer takes place on, say, 9th of May 2023, it is possible to contractually agree that the transfer would have deemed to take place from an earlier or a prior date, say 1st of April 2023. Now, typically we have seen parties do that because it allows a lot of operational and accounting ease when the business transfers on the first day of any financial year. And from a risk allocation perspective, how this works really is that the seller's risk is obviously limited to a shorter period of time, 1st of April, 31st March in this case, and the buyer's risk therefore gets extended accordingly. So this is also a risk allocation tool. Next slide, please. Now, I've been mentioning that there are certain intrinsic tax considerations, and while the subject matter of this webinar is not tax, but the M&A aspects of a business purchase, I really cannot go ahead without explaining some of these concepts because they're so intrinsic to a slum sale. Now, as I mentioned earlier, a slum sale, generally speaking, will allow a more tax-efficient route for a seller while selling its business. Of course, whether or not factually it is a more tax-efficient route will really depend on number crunching. But it is sufficient to know that there is a separate computation that is prescribed under the Income Tax Act for calculation of gains in case of a slum sale, in case of a business transfer by way of a slum sale. Now, all the gains that the seller makes for the sale of the business to the buyer will be taxed as capital gains tax, and it is linked to duration of holding of the business undertaking. So any business undertaking that is held for more than 3 years will be taxed as long-term capital gains, and anything less than that will be taxed as short-term. Now, from an M&A practitioner perspective, what one must bear in mind is that the consideration that the buyer will pay to the seller will have to meet a minimum price. Now, this minimum price will be computed according to the mechanism which is given under the Income Tax Act, and a valuation certificate will have to be given by a chartered accountant. So again, from a transactional aspect, this is an important condition precedent that the buyer must factor in, and also while discussing and arriving at the final timeline for the business acquisition. Now, the other tax implication is, of course, indirect tax. And perhaps this is the biggest driver that is driving business sales today by way of a slum sale, is because there is nil GST incidence when there is a transfer of business by way of a slum sale. And the rationale for this really goes back to the concept of an undertaking. In this case, there is no itemized sale. The seller is not selling separate assets. It is selling its entire business undertaking, including liabilities. And therefore, GST is nil, and one can save on the 18% GST hit, which would otherwise have got attached. Now, of course, no tax discussion is complete without a discussion on tax risks. And there are two risks that I want to highlight from an M&A perspective. The first risk is called successor liability that a buyer must be aware of. Now, what is successor liability? It is nothing but the fact that a seller, the buyer of a business, becomes responsible for the tax of the seller from the completion date and also for 2 years prior to the completion date. So T-2 and then or the period post completion. Now, this is a statutory provision and it will trigger on two circumstances. Number one is when the seller cannot be found, cannot be traced for whatever reason, or secondly, if tax is assessed and cannot be recovered. Now, in such a situation, obviously the tax liability moves on to the buyer. And there are various ways to mitigate this risk, but the cleanest and I think the most easiest way to do that for a buyer is to ensure that a robust tax diligence is done and that a robust warranty and indemnity package is being agreed and hardwired into the agreement. Now, the other tax consideration and risk that one must bear in mind is popularly called a Section 281 tax risk. Now, this Section 281 of the Income Tax Act is notorious because it gets, triggered in almost every mode of acquisition. So, if there is a sale of shares, assets, or in some cases in business transfers as well. And in such a case, the law basically provides that if there is an alienation of assets by the seller during the pendency of any tax proceedings, then the purchaser may become, the entire transfer, in fact, may become void if that tax liability cannot be recovered. So, of course, it's very, very critical from a buyer perspective. Now, there is a moot question here on whether Section 281 is really applicable to a business purchase, given that the section only talks about a transfer of assets. But again, from an M&A practitioner's view, at least while advising the buy side, it has become almost common practice and market practice now to ask for a Section 281 NOC. Now, what this NOC really does, and this is a workaround that the law provides, is that if the buyer and the seller, they approach the tax department and the tax department will give a no objection clearance for the transfer, then the buyer's obviously risk is mitigated to that extent. Now, again, from a timeline perspective, this NOC, in our experience, can take anywhere between 10 days in a best case scenario. It can go up to 4 weeks to up to 6 weeks. So again, from timeline perspective, one has to factor in the Section 281 NOC requirement into the final timeline. Next slide, please. Now we have a small poll question, if we can have the poll slide as well. In this case, there is a company, a seller, which is engaged in the business of manufacture food products and chemicals. Now, the seller sells its chemical division to the buyer for a lump sum consideration without assigning any values. Now, the assets that the seller transfers to the buyer are all the fixed assets, the know-how, documents, licenses, all related to the chemical division. All the current assets and liabilities are retained by the seller, not get transferred, and all the employees are also not transferred. Now, in a moment from now, you will have a poll question in which I'll request you to put in your thoughts on whether you think this is a slump sale of business, as we have just discussed, or not. Can we launch the poll, please? I'll wait for 5 seconds for you all to please kindly put in your responses. Can we have the results, please? Thank you. Can we have the results? Thank you so much. So I see a majority of y'all have chosen no, which is 53%, and that is in fact the right answer. And the facts of this case, which I just presented, have been taken from an order of the Income Tax Appellate Tribunal, in fact, where it was held that this is not a slum sale of business. And the rationale for that was that at least the tax officer, the appellate tribunal, considered that this would be akin to an itemized sale of assets, given that there was a complete non-transfer of all the current liabilities, of all the employees, of all the current assets, and this could therefore not be qualifying as a slum sale of business, which means that it would obviously not be taxed as a slum sale, will not have the benefit of the tax computation that we just discussed. Next slide, please. So in this slide, the idea behind the slide is to just provide a broad overview of the various stamp duty rates that could get attracted for the various agreements that a slum sale of business would have. We've taken two sample states, Delhi and Mumbai, but really the driving point here, what I want to talk about is the fact that in a slum sale, in a business purchase, it's just not one agreement that we talk about. It is, there are several ancillary and incidental documents as well. So of course, the master agreement will be the business purchase agreement. But usually if there is immovable property, it is quite common to convey that immovable property through a separate deed of conveyance. And the reason for that is, as you all know, a conveyance deed is a registrable document. It becomes public in nature. And of course, parties may not want their commercials, which are mentioned in the business purchase, to become a public document. Similarly, if there is intellectual property, it is quite usual to have an assignment agreement. For contracts as well, there could be assignment agreements, there could be novation agreements, etc. Next slide, please. Now, let's move on to the second part of my presentation, where I want to talk about certain transactional aspects. Now, in a business purchase, timeline planning becomes extremely important. And the reason for that is there are several checks and balances, several conditions precedents that would come into play, and a lot of external stakeholders as well. So I just want to discuss a few key conditions precedent here. The first and the most basic, of course, is your charter documents. Now, both in case of a seller and a buyer, they should, the first check and the basic check a diligence will do is see if the charter documents of the companies have an enabling provision which allows for the buy and sale of a business undertaking. Usually this is not a problem because most charter documents would have such an enabling provision. But in addition, the buyer should also check whether its memorandum of association, the main objects clause, allows it to carry on the business that it wishes to purchase. So going back with our prior example, if you have the cargo division of the airline being transferred to, say, a chemical company, then perhaps you may need to look at your charter documents and have those amended. Another very important point is your prior approval of the Competition Commission of India. Now, as you may know, any transfer of shares, voting rights, or assets would require a prior approval of the Competition Commission of India in certain cases. And a business transfer is really no different. So in case of a business transfer is meeting certain thresholds which are prescribed under law, and these are usually connected to asset size and revenue, then a prior approval would have to be required. Now, of course, the outer timeline given under law is 210 days for us to receive the approval. But in my experience, it can take anywhere between 2 to 3 months for a non-controversial case to receive such approval. So again, a very, very key point to bear in mind from a timeline perspective. Again, for transactions that are likely to happen this year onwards and this point onwards, it's very important to remember that our competition laws are presently undergoing an amendment. And there are certain new thresholds that are being contemplated. And these are linked to deal value, or if the target entity has substantial business operations in India. Now, what is deal value, how that will be calculated, and what does it mean by substantial business operations? They are all gray areas and moot questions right now, and we'll have to wait for the notified rules. But that aside, this must be an important, I would recommend that we keep this in the back of our head before proceeding with any transaction this year. Again, corporate approvals will be required. Like in any other mode of acquisition, board approvals are always required. But in the case of a business transfer, the seller would also require to take a shareholders approval, and that too of 75% of its shareholders, if the transfer is a transfer of an undertaking. Now, again, undertaking here is not the undertaking that we understood as it was defined under the Income Tax Act. There's a separate, more, I would say, more precise definition which is given under the Companies Act, which is linked to either the income that that business unit is generating or the investment that the company has made in that particular unit. Again, there are certain stock exchange disclosure norms as well. So if the parties are listed, a stock exchange disclosure must be made within 24 hours of the signing event, usually on the signing of the definitive documents. And finally, we come to a very important aspect, which is consents. Now, in a business transfer, usually several consents will be required. So one has to check during the diligence process all the contracts that the company has, that particular undertaking has, with lenders, with contractors, with customers, insurers, for example, and if there is a consent requirement, then prior consent must be taken. So from a timeline perspective, this has to be factored in because it could be quite time consuming as well. Next slide, please. So I want to discuss these various components of the business transfer and the transfer clauses in a slightly more detailed manner here. Now, as I mentioned earlier, when there is a business transfer, it has to be a business, entire business undertaking, which means, of course, there'll be various moving parts and various components of that business that the purchaser is acquiring. So, for example, if there is immovable property involved in the business, then the first point one must check is that if it's freehold or is it leasehold. If it's freehold, things are fairly simple because the parties will sign the deed of conveyance, pay the stamp duty, registration fees, and the property transfers to the buyer. However, if it is leasehold, certain additional checks may need to be done. So in a leasehold property, first thing I would recommend is to check who is the lessor. Is it a private party or is it a state industrial corporation, some state authority or the government? So for example, in Mumbai, you may have the MIDC or you may have UPSIDC or other such authorities. Because more often than not, when it is a state authority, there could be an underlying legislation as well that you have to check. And you need to check if there are consent requirements, if there are transfer taxes that are payable to such authority. So once that check is done and the requisite consent or transfer taxes are paid, then the property can move over to the buyer. This can happen through various ways. You can have a sublease arrangement, you could have an assignment of the lease deed, or in some cases, a fresh lease agreement may also be signed by the purchaser. Now, movable property is fairly simpler in approach because movable property is usually transferred through the main master business purchase agreement, and it is transferred by a delivery of the physical possession of the movable property. Now, of course, you can choose and opt to have a separate deed of conveyance, but then again, separate stamp duty, etc., will be paid. For intellectual property, now if it is owned intellectual property, parties will usually have a assignment agreement for transfer of that intellectual property. If it is registered, then certain post facto intimations will also have to be given to the relevant authority, say a trademark authority or patent. And if it is licensed intellectual property, then of course you may have to enter into a sub-license agreement or a fresh license agreement. Again, consents may be required at this stage. Now, the next component is very, very important for any business transfer because in India, no business can really be done without the plethora of licenses and permits that accompany it. Now, unfortunately, most industrial licenses, or I would at least say a majority of them, are non-transferable in nature. So, for example, your fire NOC, factory registrations, environmental clearances are non-transferable. Then there are certain other licenses in which you could have a name change or an address change application. And in certain other licenses, you need to make a fresh sort of application for the transfer. So depending on the license, the nature of the license, also the validity of the license, the buyer can either procure fresh licenses or have them transferred. Now, the time taken for transfer versus procurement of fresh licenses are almost similar. So we usually find that buyers prefer getting new licenses altogether to avoid any legacy issues with that. And also buyer controls the process as well to some extent. Now, for contracts, there could be, of course, several types of contracts in any business. There could be customer, vendor contracts, service contracts, etc. In all contracts, there could be assignment consent requirements. Now, under Indian law, if there is no specific assignment clause or it's silent, that means a consent of the counterparty will be required, and that must be borne in mind. So once the contracts, the consents are received, then the parties can have an assignment of the contract, or they could also have a novation agreement, which is basically where the seller is substituted by the purchaser. And then we come to employees. Again, a very, very critical aspect of any business. Now, employees, again, there are several considerations at play. For employees, one must consider, are they workmen or are they non-workmen, or are they contract laborers? Now, for workmen, again, is quite unique because there is a statutory provision that governs the transfer of workmen. And the law requires that the two conditions need to be made. And these two conditions are that there should be no break or interruption in the employment of that workman. And secondly is that the workman should be employed on terms which are not less favorable than already available to it. Now, if these two conditions are met, then this entire transfer does not get categorized as a retrenchment. No compensation, therefore, is payable. And usually these two conditions we will hardwire into the transfer clause itself, and the transfer clause will mention and satisfy the purchaser that these two conditions will be met. Now, for non-workmen category and workmen, usually consents are typically always taken. Contract laborers, of course, are slightly different. In most cases, the purchaser will enter into a fresh contract with the contractor for use of such contract laborers. Now, two other aspects, insurance. Now, insurance, of course, is possible to be transferred by way of endorsement. Again, a consent of the insurer may be required. But usually, again, we've seen that the purchaser entity, depending on the commercials, the coverage that it seeks, the premium payable, etc., may want to just get fresh insurance coverage. And again, litigation, there are various ways to deal with existing litigation. Of course, if litigation is excluded, then that's not a topic for discussion. But if the litigation is carried on, then of course, one could make an application and change the parties to the litigation. But usually, instead of going through that route, the purchaser has a contractual arrangement. Either the seller could continue the litigation at the purchaser's cost, or vice versa, the purchaser just could continue the litigation at its own cost. Next slide, please. And then I come to a very important point, which is risk and mitigation. Of course, I cannot stress enough on the fact that risk mitigation aspects are key for any mode of acquisition. And especially so in a business transfer, because we discussed there are so many legacy issues that can come with the assets. You're also taking over the liabilities of the business undertaking. Then there is successor liability. So in order to mitigate that, the best package to really do that is your reps warranties and indemnity package. Now, typical representations and warranties for a business transfer would be, for example, that the business is carried on properly, the assets are working properly, employee dues are paid, taxes are paid, financial records are in place, and they're all limited to that particular business undertaking that the purchaser buys. And there could be some important undertakings or covenants as well. Now, covenants typically would be that are critical, are further assurances where the seller is, covenant, basically giving an undertaking to the buyer that it will provide all assistance required, sign all deeds, documents, and everything necessary to really ensure that all the business transfer is effectively implemented. There could also be further assurance, apart from further assurance, there could also be standstill considerations, which are very important because, the purchaser would want to make sure that the business really does not have any leakage, there is no adverse business impact for the time between signing and closing. And therefore standstill becomes very important. And finally, indemnities. Now, for all known and unknown liabilities, it is usual to have an indemnity package. Now, I won't get into this in more detail here because my partner Vidushi Gupta has done a bespoke session just on this point, and I'd recommend you all to watch this on our YouTube page where we've discussed these aspects in more detail. Next slide, please. I think we are moving on to a poll question, and I'd love for you to please participate here. What, in your opinion, basis all the discussion that I've had over the last 30 minutes, what, in your opinion, is the most critical aspect of a business transfer? Do you think it's the tax considerations, defining the property sold and excluded, or do you think it's the timeline planning of the CPs, or all of the above? Can we launch the poll, please? Thank you. I hope everyone's been able to put in your responses. Can we have the responses, please? Okay, so again, an overwhelming all of the above, and I couldn't agree more with the majority opinion here. Of course, tax, and can we move on to the next slide? Of course, all the three components are extremely important, but I would say it's all of the three aspects that are on your slide. So first of all, of course, it's the tax considerations. It's the structural parameters we discussed, the four components of a slump sale that we discussed that have to be borne in mind. They are definitely critical. Again, drafting becomes very, very important. The transfer clauses, how do you exclude your assets liabilities? Is it nuanced? Is it clear, the exclusion of the property? That is very, very important. Again, from a risk mitigation perspective, the warranties and indemnities become very, very important given the number of risks that we have discussed. And finally, it's the timeline planning, which is also key given the number of external stakeholders. And I think collaboration between business teams and legal teams become very important for a business purchase, more so than perhaps in other modes of acquisition. And with that, with my key takeaways here, I've reached the end of my presentation. Thank you so much for your patient hearing, and I hope you find this presentation to be useful. Over to you, Nidhi, for next steps.
Thank you, Suhana, for what was a very insightful presentation. I hope our audience enjoyed it as much as I did. And without further ado, I will jump right into the audience questions. We've had a very active chat box, Suhana, while you were presenting the session. We've received some very interesting questions. I'll take you through them one by one. The first one we have is on how the stamp duty is calculated on a business purchase agreement. And if you could probably focus on a movable property being transferred as part of the business transfer agreement and how stamp duty should be computed in such a scenario, that would be helpful.
Sure, thank you. Thank you for that question. A business purchase agreement, now it would usually be very nominally stamped. Anywhere, I mean, I gave the example of Delhi, Mumbai, for example. Most states would be nominally stamped, provided the immovable aspect of it is taken out of the business purchase agreement and there is a separate deed of conveyance. So let's assume there is a business purchase agreement which transfers everything other than your immovable property, and also other intellectual property which could be differently stamped. But assuming that the business transfer just does not consider and does not have the immovable property, it would be nominally stamped as any other agreement. Now, for, of course, Mumbai, there is a separate provision given for any other agreement bearing a consideration. So it would be stamped as a general any other residuary agreement clause. But the immovable property aspect of it will be separately stamped through a deed of conveyance. And usually in every state, this is going to be based on the market value of the property or the consideration that is mentioned in the deed of conveyance, which is supported by a valuation certificate. Now, usually how that would be done is you will take the market, this ready reckoner rates that are available or the circled rates, and it's usually a percentage. It's 3 to 5%, 6% in certain cases as well, and it will be stamped at that. There could be a valuation certificate required as well, and the land and all the buildings, warehouses, plant and machinery, everything that is attached to the land is considered to be part of that immovable property, and therefore is to be factored in while valuing the immovable property. And then it's going to be stamped at a particular percentage of that. So, broadly speaking, this is how it is done.
Thanks for that, Svana. Extremely helpful. I think the next question we have is on payment terms and the manner in which this can be structured for a business purchase agreement. So I'm reading the next question, which says, can the consideration be deferred? And depending on the performance of the business, can it be a variable or deferred consideration? And how would you think about that in the context of payment terms under business transfer agreements?
So yes, I think let's divide this response in two parts. Can consideration be deferred? Yes, it could be deferred. Of course, the underlying understanding here is that it should not take away from the point that it has to be still a lump sum consideration. So as long as the lump sum consideration condition is met, a portion of it, of course, could be retained and deferred. And I think that ties in with the question on payment terms. So usually, of course, you have a purchase price, and that purchase price is hardwired into the agreement. This is a very linear sort of a business transfer. In certain cases, when there is a deferred element, then you could have the payment terms, slightly more nuanced. Now, when do you have deferred consideration? You could have it, when there is a post-closing adjustment of sorts. A working capital adjustment needs to be done, for example, then it is typical that certain consideration may be deferred or kept in escrow. Or sometimes you could have deferred payments just to sort of meet any potential liability, similar to an indemnity escrow. So in such cases, it is possible to structure the payment terms to allow for these deferments. In my experience, I would say it's not the norm, but rather an exception to the norm. But of course, it is possible to have a more, deferred sort of element to the payment terms.
Thanks, Johanna. The next one we have is on transferring different sort of aspects linked to the business undertaking. The first one, and I'm clubbing two questions. The first one is on transfer of IP. And the question is if a separate IP assignment agreement is required. And the second question is on consents that are required from, say, workmen for the transfer of the business undertaking. If those are bulky or excessive in number, like say 1,000 plus workmen, for example, then how would one go about transferring such assets that form a part of the business undertaking?
That's a great question. I'll move on to the first question, which is, I think, transfer of intellectual property, right? So in that, intellectual property will be typically transferred by a deed of assignment if it is registered intellectual property. So if it's a trademark, that is say, sorry, not registered, but owned. So if it is an owned trademark of the seller, then you will have a deed of assignment where you will irrevocably and permanently sort of transfer that to the buyer for the benefit of the buyer. And like I mentioned, if it's registrable, then you may need to make certain post facto intimations. Now, that is one way in which intellectual property can be transferred. Another way could be, of course, if it's not owned, then you could have just a license arrangement, a sub-license arrangement, if the seller still has some skin in the game and wants to further license it. Or the buyer could just enter into a fresh license agreement with the relevant licensor. Of course, consents may be required in that situation as well. Now, sometimes when there is no major intellectual property and you may just have a, say, a brand name or a copyright or something which is not registered or something which is not owned or, very formal in nature, know-how, etc., then typically this will get transferred through the business purchase agreement, through the, generic clause in the business purchase agreement that transfers all the intellectual property. So that is how intellectual property will usually be dealt with. And the second question, which is transfer of workmen. And I think the question was, what happens if there is a large number of workmen that are to be transferred? And I think that's such a pertinent question because that happens often. And in that situation, I think there are several considerations at play. Number one is, not only the number of the workforce, but also the locations of the plants. Like, for example, how spread out, how many factories, because that will also eat into the timeline planning and the feasibility of procuring consents from every workman. Again, what is the literacy levels of these workmen? Are they able to comprehend the transfer to begin with and the various terms? Now, under law, there is no prescribed manner in which these consents have to be obtained. The law only says that informed consent is required. So now we've come like most M&A practitioners have come out with various creative ways to deal with it, really. So in my experience, we've had situations where even with like 1,000+ workmen, we've had in-person consents required. But in certain other cases, we've done mainly a town hall meeting where all the transfer terms are well explained. And then, you get either transfer notices are provided to the workmen or in-person consents are taken. In certain other situations, especially when workmen are not able to comprehend, the dynamics of the transfer, then it is also common to have the trade unions engaged with them, where the trade unions will explain to them that, these are the terms of the transfer, and following which a public notice may be put up in the relevant factory. And that's like a deemed consent requirement as opposed to an express consent. So all of these permutation combinations are possible in such cases.
Thanks, Suhana. I think we have time for one more question, and the rest that we were unable to pick up, like I mentioned, we can respond to those offline after the session. But I think your response right now is a good segue into our last question, Suhana, where one of the participants has asked that in case of a license that you're not allowed to sub-license, how would you deal with licenses of that nature? And if there is a requirement for the buyer to obtain a new license, then does the seller have any obligation to assist?
So thank you for that. I think let me take the second aspect first. Does the seller have any obligation to assist the buyer? Is that right, Nidhi? Yes.
That's
So
correct.
Yes, so I would say yes, more 100% yes to that. Whether you're the sell side or the buy side, I think it is typical for sellers to provide that assurance to the buyer and say that, look, we are giving you, of course, our business, we are selling the business, or I'm taking the business from you. And it is but obvious that any, any documents that need to be signed, any licenses need to be procured as the seller of the business, they would have more say and they would have to make, provide necessary arrangements, necessary information to the buyer. And so it becomes very important to provide that information, to provide that assurance to the buyer. And it is typically done in most business purchase agreements. I can't remember of a single instance where a further assurance was not provided really. So it is very important. And for the first question on a license, what happens if there is no sub-license possible? Is that right, Nidhi? Yeah, so in such a case, if a sub-license is not possible, and I'm referring to licenses here for licenses and permits for your business, for the operational licenses. So in such cases, of course, you will have to make a fresh license arrangement. Now, what that obviously implies is there could be a time gap, because when you're making a fresh application for a license and procuring that license, it is a time consuming affair, at least in India. So there could be certain alternate arrangements that the buyer and seller could also enter into. So for example, they could have a shared services agreement, or what is popularly called job work contracts, where the seller continues to operate for and on behalf of the buyer, in trust of the buyer, using its own licenses. So, these kind of workarounds are also possible, but the short point being that finally a fresh license needs to be obtained. I hope that
Thank you.
answers the question. Yeah.
Absolutely. Thank you, Sohana. We're continuing to get more questions in the chat box. Like I mentioned previously, we'll respond to them offline with all the presentation materials. So you'll be hearing from Sohana and the team at Khaitan and Company in due course. Thank you, Sohana, for that. Was a really thought-provoking session. At least to me, some of the key takeaways were that it sounds like the proof of the pudding is always lies in the eating, and how successful a business transfer really is will depend on how well one is able to execute it and take it to completion. And to that end, all the pieces of the puzzle need to fall in place. Planning is a key aspect for successful implementation of a business transfer agreement. To that end, it's very important to check the transferability of each asset that you're looking to transfer as part of the business undertaking, whether that's a license, a contract, or even employees, etc. It's very important to understand the manner in which these will actually stand transferred from the seller to the buyer, and to make sure that the contract accurately reflects that. And the second thing, Sohana, that I think you really touched upon well, and something that our audience should certainly keep in mind the next time they're working on a transaction of this nature, are regulatory approvals. One often tends to think that something like a Competition Commission of India approval is triggered only when we're considering share sale acquisitions. But these are equally important when you structure transactions through business transfer or asset arrangements as well. So thank you, Sohana, for highlighting that. Before closing, I would like to ask each of you to respond to the poll slide on your screen. If we could move to that, thank you. Please provide us with your feedback on today's webinar. We take this very seriously as part of our continuous improvement program and ongoing development, so we can continue to bring to you world-class M&A Academy sessions going forward as well. So if you could please spare a few seconds to participate in this poll, we would be really grateful. Thank you to everyone who's participated in the poll. Finally, I would like to thank Sohana for her presentation, and also to our audience for your attention and for being so interactive. I hope you found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, we will send you a copy of the presentation along with the summary notes and a link to the webinar recording. You will separately receive a request for your feedback on the webinar. Please take some time out of your calendars to respond to this survey. Any comments, criticism, or compliments are welcome. The form will take less than 1 minute of your time. If you are interested in in-house training or any other matters arising from the webinar, please do not hesitate to contact us. Our contact information is at the end of this webinar. Thank you so much for your attendance today, and we look forward to being with you again in future M&A Academy sessions.